Steinfeld?
Thank you. May it please the Court, Kenneth Steinfeld for the Commonwealth. The principal issue that I would like to focus the Court's attention on this morning is the trial judge's lack of authority to vacate a conviction when it allowed her Rule 29 motion.
Right. So your argument is, and probably right, you can't revise and revoke the guilty. Was this a plea here?
Yes, it was.
Plea.
It was a plea.
Yeah, she admitted to sufficient facts.
Change the sentence, but you can't.
You can't. You
Absolutely.
can't withdraw the guilty
Absolutely.
plea.
Once Judith
So,
McCullough.
so you don't disagree with the restitution order?
Oh, absolutely not. We think
And that's
that
not
was,
even here, right?
right. That
And he's
was
paid it. And
fully supported by the record. It
So
was
the
documented.
remedy
We
you're
do not
looking
appeal
for
that.
is reinstatement of the conviction.
Yes, that's correct.
But isn't this moot?
What about the mootness problem?
Well, the defendant claims that it is moot because the Commonwealth did not seek a stay. But I would submit that the brevity of the continuance period of one single day, it would be impractical and it would be unrealistic to have expected the Commonwealth to have sought and obtained a stay in that very short period. The quaff was for one day, and the very next day the case was in fact dismissed. So I think that it would be unfair to permit Judge Morey's order to be insulated from appellate review by the mere expedient of having done it so quickly.
Let me ask you this, Mr. Steinfeld. If we agreed with you on the law so that it's clear that in the future you can't do what the judge did in this case, if it's clear the restitution is there, and we then rule that it's moot, does that present a problem for you?
Well, it does, because
It does because you want the conviction on a record.
yes, we want the conviction that the Commonwealth obtained and was entitled to hold on to.
Okay.
And therefore, I think the Court should exercise its powers under 211(3).
And you're entitled to, now of course we'll hear from the
I
other
take
side,
it-
but you feel you're entitled to have this conviction in case this person commits another crime, whatever.
Absolutely.
And I take it you would also be unhappy about having mootness resolve something when the period to bring an appeal is one day. I mean, it's sort
Absolutely.
it is, as you say, insulating the...
And
Absolutely.
you did bring the 211.3 in what, within 2 weeks?
63 days, I believe.
Why'd you wait so long?
Well, there's nothing in the record, but I was trying to obtain the transcript and of the part that was recorded. Most of the important events here were not recorded, but those
Wait,
that
this is the
because they
Washington-
occurred.
Oh, okay.
Pardon me?
No, I'm just trying to. This is up in Essex County.
Yes.
But in any event,
yes,
the one
in
day,
Gloucester
the one
District
day somewhat insulates that issue because
Yes,
you
it does.
couldn't
And
do anything in one day.
And I think it also makes it clear that if the Commonwealth had moved in the trial court for a stay, the likelihood of success would not have been very great. And though we in appeals like to think of ourselves as supermen and superwomen, I don't know whether we could have come to an appeals court in time to get a stay to prevent the quaff, the one-day quaff from having
Was a
expired.
motion filed for a continuance or for time to pursue
No,
an
there-
appeal?
No, the Commonwealth relied on the general principle that a 211(3) petition may be filed at any time. And I
Let's
did
see,
it.
you would have gone to the appeals court for a stay, would you not?
Yes.
Yes.
Yes, but we thought that I thought that the one-day period had expired, so that issue, it's either moot or not on that day, and that there was nothing we could do afterwards because she would just say she'd served her entire sentence. The second sentence, the one-day quaff.
So let me. I'm sorry. Finish.
Well, no, I'm done.
I'm just looking at your order for relief, Mr. Steinfeld. So what you would like us to do is to reverse the order of the single justice, remand the case to the county court for the issuance of an order, vacating the trial judge's order, allowing the revise
And revoke.
to allow the revise and revoke, or you want us to vacate? Are you describing what the order does?
Yes, there were 3 orders that Judge
So
Morey
you
entered.
want us to vacate all of those
Right.
and do what? Anything else?
Well, once those are vacated, well, I expect I should have
And
added
then
remand
we'll-
for further
the-
sentencing that was consistent with the original.
No, that's not what you want. What you want is,
From conviction.
I hate to tell you what you may want. May I suggest what you might want?
Yes,
And that is
absolutely.
to vacate so much of the revise and revoke as purports to
Strike the guilty
strike the guilty plea
and find
in
him
order that
guilty.
the guilty plea be, the conviction resulting from the guilty plea be reinstated. That's it.
Yes, that would certainly satisfy the Commonwealth.
Because the restitution's been paid, and you're not, she wasn't ever going to do any
You don't want any
time anyway.
resentencing on anything else. She's
No,
done
what
her time,
I
paid
started
her
to say was
restitution.
to impose the previously imposed, to impose the previously given sentence.
Sentence?
Not for resentencing. Of course, I don't want that.
What's the previously given sentence?
It's
This
administrative
alternative-
1 year
probation.
probation.
But, Mr. Steinfeld, even if the judge had for some reason been proper in considering this, whatever
Even if-
reason, the defendant's affidavit doesn't fit under Rule 29 as we've
Absolutely
interpreted,
not.
because you're only supposed to consider events up to the time of sentencing, and the affidavit says that she stayed out of trouble and she's complied with probation, all post-sentencing considerations. So
Not only that,
on the
Justice-
merits, it's improper.
I fully agree with Your Honor, and I would add that that affidavit is not even from the defendant herself. It is from her counsel, who says, my client has done her best to stay out of trouble. My client has done her best to comply with the conditions of her probation. And I think it's obvious that it's impossible for one person to say that another person has done those things.
Are you
so I think
appealing
that technically,
that? Are you appealing that portion of the order?
yes, we
You're appealing the whole order.
the whole order. There's no basis to allow the revise and revoke whatsoever. One of the reasons why the whole order should be vacated is the lack of a competent affidavit, which the rule says that you have to set forth in the affidavit the facts that support the grounds for the motion. Furthermore, Judge Morey did not mention or rely or even discuss the facts in the affidavit. His finding was very, very clear. He said, I was not at all concerned with the defendant. I was not concerned with the justice of the original sentence. He said, my sole concern was to make sure that the Kelleher's had money so that they could attend school. That is an improper basis to allow a Rule 29 motion. That, in effect, means that the sentence is not complete. It is not harsh enough because Ms. Kelleher has not been compensated. Therefore, the requirement that the judge make a finding that justice has not been done based on facts that were in existence at the time of the sentencing is just not met here. And that affidavit, to go back to that affidavit,
And what saves you is the one-day thing. That's what saves you. Otherwise, you'd be way in delay on everything.
for mootness grounds, Your Honor?
Yeah.
Yeah, I think there would seriously be a problem. Most of the cases,
What was the cause of this accident, by the way? Was that ever ascertained? I mean, she got 0 on the breathalyzer, so it wasn't alcohol.
no, there's nothing in the record. I know
she
what the
just
police
black out or
suspected,
something?
but there's nothing in the record, so I don't think that it would be appropriate for me to speculate.
So
as to what
basically,
caused
what
it.
the record shows is negligent driving.
Right. She took a left turn 83 or 84 feet before the street that she thought that she was supposed to be turning on. So we have no idea what caused it. But the fact is that it was a very serious accident that caused injury to 2 people very severely. And the Commonwealth...
1-year probation was the sentence.
Right.
Administrative probation.
Yes.
Now, what is that as compared to regular? You don't have to report?
Yes, exactly. Do not have to report. The Commonwealth does not have any problem with that as a sentence. The judge is powered...
So your case really comes down to this. You got a conviction, guilty plea, the 1-year probation, and then a revise and revoke that was done in 1 day, or sentence was 1 day, that A, was wrong as to the sentence part of it, the revise and revoke the sentence, and B, wrong as to attempting to strike the guilty plea.
That's right.
C, wrong because the affidavit was improper under Rule 29. And D,
why the
and D,
revise and
wrong
revoke was
because
no
his
good.
explanation was, I'm not focused on the defendant, I'm focused on one of the victims of the accident.
That's correct. The Commonwealth merely wants what it already had and what it was entitled to hold on to. The only way that the defendant could set aside her conviction would be through a Rule 30 motion or through a successful appeal. I think the cases are absolutely clear on that point.
Would you
What do we
say
do
that-
about, I'm sorry, go ahead.
Would you say at this point that, let's say, all those things that you got back, would you say that the sentence could be
Deemed.
deemed served or non-pro-tunc? I mean, that it, yeah. I mean, are you looking to have another year probation served?
We are primarily concerned with the fact of the conviction. We also think she should serve a year on probation in case
How
anything
much-
happens,
how
but
much-
we could live with the non-pro-tunc.
Okay.
What
How-
about the
how-
six,
Sorry, Justice
I'm
Skinner.
sorry, go ahead,
Go
Chief.
ahead. No, you go ahead.
what about the $6,000 that the defendant paid?
It's already been
That's
paid.
been paid. He's
Yeah, but
okay.
it was paid as a result of the motion, the Rule 29 motion, wasn't it?
No,
Yeah.
that day was set up for a restitution. Yes, it became part of the Rule 29 proceeding, but it should not have. That hearing was scheduled
In any
for
event.
restitution. That's why we're all here. She brought her lawyer, her father, Ms. Kelleher, I mean the principal victim, to document, and she did her $6,000 in damages. The defense lawyer stood up and said, Your Honor, how about a quaff? I would like a quaff. And so they
So the
talked
hearing
about...
was on a restitution. The judge was going to order restitution, providing that the evidence supported
Yes.
the amount of restitution. And so the Commonwealth had a guilty plea, it had a sentence, it was now moving to restitution. So had things gone along as the Commonwealth, excuse me, Mr. Steinfeld, anticipated, you would have had a guilty plea sentence and restitution. Correct? Is there anything, to follow up on Justice Spina's question, is there anything in the record that suggested that the judge ordering restitution was in some way dependent on the quaff? No.
It was absolutely dependent upon it. He made it clear they actually tried to negotiate. Defense counsel said, well, I'll pay $3,000. The judge said $6,000. It was very clear from the record, I believe, and from Judge Morey's findings, that if the defendant did not agree to pay the $6,000 then and there, that day, to the Kellehers, she would not have received a quaff. And that's the Rotunda violation.
I was going to say, isn't that an additional violation here?
Yes, it is. That is the first argument in the brief.
But doesn't that present us with Justice Spina's problem? Because here you don't have I don't have some independent record of the judge saying this victim is entitled to this amount of restitution. I mean, in other words, I don't know whether the defendant has to agree to restitution or could challenge it, but we've got a very messy record here, correct?
It isn't so messy, though, is it? I mean, I thought that was, it was understood that there was going to be restitution, and it was going to be up to the Commonwealth to bring the victim in to establish the amount that would be appropriate
Yes, that's
for restitution. And that was done. I don't think anybody's disputing that the
Right.
amount
I
was...
think that's the cleanest part of this case.
But I thought you just said or at least the sense that I got from what you said was that whatever affidavits or medical bills they submitted or lost wages, it came close to the figure of $3,000. And then the judge said, look, I'll give you a quaff if you give them a little pain and suffering.
No, the figure was closer to $6,000. There are several bills in the appendix. One is for $2,200, then there's another one. It was clear that the damages that she suffered approximated the $6,000. This was not like in Rotunda where the $5,000 figure was randomly pulled out of the air by somebody. This was definitely
Actual damages.
actual damages, the best approximation that they could do. And therefore, the order
So where did the $3,000 come?
that was a bargaining chip by the defense counsel.
With
who
whom?
said with the judge.
What was the basis for them saying $3,000?
None at all, Your Honor.
We're going to
He's-
give defense counsel an opportunity.
He said, the judge said pay $6,000, and he said, how about $3,000? It was a counter proposal to the judge's proposal that he would give a quaff upon payment of $6,000. He said, how about $3,000? The judge, as he said in his findings, I stood firm on $6,000 because that's what the Kellehers needed and what they had proven were their damages.
Okay.
I'll be happy to rest on my brief, and thank you for the additional time.
Thank you, Mr. Steinfeld. Mr. Laredo?
Yes. Good morning. May it please the Court. Mark Laredo for the respondent appellee, Judith McCullough. Briefly, this case, as the Court is well aware, arises out of an auto accident. It's a
Why
charge-
did the lawyer file something that's in effect asking for improper relief?
Your Honor, the Rule 29 requires two things, a motion and an affidavit. Those were filed here. Could this affidavit have been different, perhaps better? Yes. Does that obviate what the trial court judge did and the single justice did? I suggest the answer to that
but
is
to
no.
revise and revoke doesn't give the judge authority to vacate a plea.
He didn't vacate a plea. I would suggest that the revise and revoke here was entirely proper. In March, when the judge entered his initial sentence, he had the power at that time, and it's undisputed, to enter a continuance without a finding. That's what this was all about. It was a pretrial procedure.
But what did he do?
He entered at that time, he took 2 disparate recommendations, and he entered a guilty with an administrative probation.
Isn't that the defining event right there?
No, Your Honor, because this is not a trial. Had this been a bench or jury trial, had jeopardy attached at that point, then quite clearly under this court's teachings, after a bench trial or after a jury trial, the only thing that a judge may do is either find guilty or not guilty. Not so here.
Didn't she plead guilty?
She admitted to sufficient facts, Your Honor, and this...
Isn't that the equivalent?
It is. But the judge had the right in March to issue a continuance without a finding. That was quite clear. That's not challenged.
But
This was an
once the
appropriate-
guilty, but isn't Josephina right that once that guilty plea is taken and the conviction entered, don't you then have to move on to Rule 30?
No, Your Honor, because this is not a per se conviction. This is the sentence. The judge had the discretion in March to sentence as follows: either a continuance without a finding or the guilty with administrative probation.
But would you agree with me that, Ross, that an admission to sufficient facts, and she did that,
She did, Your Honor.
to be found guilty, all the cases say that's the equivalent of a guilty plea?
Your Honor, there is an equivalence there, but the question here is whether the judge had within his power to do what he could have done back in March,
But under
what he
Rule
did in May.
29, the only power the judge has is to change the sentence.
But the sentence here is a continuance without a finding. That is the sentence here. That is the sentence the judge imposed.
But the guilty finding that the judge made originally is not the sentence, and
But-
that's what he changed.
But that's not what's being challenged here, because in March, the judge took a tender of the plea, okay?
Did he go through a colloquy with her?
I presume there was some colloquy at that time. I wasn't present, Your
He
Honor.
imposed a sentence of administrative probation for 1 year.
With the understanding that there was then going to be a hearing on restitution. And
Right.
the defendant was prepared to go forward at that time on restitution. The court deferred to give the Commonwealth an opportunity. We're back in May.
So you got a guilty plea and a sentence of probation is what you got on that day.
You have
Restitution down the road.
the judge, the district court judge, exercising his discretion, because he could have in March.
He could have, but he didn't.
That's right. And he reconsidered, he revised and revoked his decision within 60 days.
But, Mr. Luriera, you're saying that
Sure.
every time a judge has the power to do a quaff, but instead finds the defendant guilty, he can use or she can use Rule 29 to undo that?
I would suggest that it's not, it may be every time, but Rule 29 is a very tight window, Your Honor. It's 60 days. It's not unlimited.
Yeah, but it also has tight conditions. It only applies to the sentence.
And I would suggest here, Your Honor, that the sentence imposed was this continuance without a finding. That's with restitution. That's what the judge did in May. And that was permissible. The distinction here is trial versus non-trial. That's what this Court's teachings, and that's what the Gomez case says. Once you have jeopardy attaching and you have a trial, then the judge loses his or her freedom to impose a different type of disposition.
You don't think that entry of guilty is going to mean jeopardy has attached?
I do not believe jeopardy is attached. There's been no trial here, Your Honor.
Well,
She
but there's
waived the
been a
trial.
conclusion of its trial.
She has waived the right to a trial, and she
Waived the right to jeopardy.
That's why the colloquy occurred.
I would agree a colloquy occurred. I would suggest that
Because if what you say is true, then every time somebody pleads guilty to something, it really keeps open this whole possibility that anything can happen because jeopardy didn't attach.
not so, Your Honor, because it depends if a continuance without a finding was an appropriate disposition or not. Continuance without a finding is not, as this Court knows, an appropriate disposition in a variety of circumstances. It was so, however, here. That was the sentence effectively that the judge imposed when he revised and revoked his decision.
But I take it what you mean then is that Mr. Steinfeld could, in this instance, I mean, if they had a little bit of evidence, could have reopened this, brought charges for operating under the influence?
I don't think that would have been permissible at all, because this is
Why?
Rule
'Cause-
29, a revise and revoke
Yeah,
the
but you
judge's
just said that there's
disposition.
no jeopardy. He could charge.
I don't believe the judge, that it could be charged here, Your Honor. May I just turn briefly, if I may?
I just want to, I'm trying to
course, Your
find
Honor.
his order. I'm reading Judge Morley. Record Appendix, page 12. Thus, in the case of a finding of guilty imposed upon the defendant's change of plea, right, that's what we have, the COA has the power to revoke not just the sentence, but also the entry of a guilty finding and the guilty plea itself. That's what the judge said, and that's what the judge did.
And that's wrong.
I would suggest that may be what the judge said. And maybe,
And it's also wrong.
I mean, I'm not, it's not human, but I mean,
no, I understand, Your
it's
Honor.
pretty clear what he thought you know, sometimes it's not so clear. You know, he'll say, I revise, revoke, and then the docket is I mean, he's very clear, and he cites to.
Were you the lawyer when all this occurred?
No, I was
Or
not,
you just
Your Honor.
inherited this mess?
Oh, you did a good job.
I came on rather late to the scene, Your Honor, where my
Very
firm
good
is
job
appellate
putting the
counsel.
record together.
May I just briefly touch upon something? Even if this court is quite troubled, perhaps troubled by the procedure employed, there are two issues here that render that this court doesn't have to reach those issues, or at least not for my client. The first is, as it was alluded to, is the mootness issue. There is no doubt that there is a one-day space here between the day of the revise and revoke and the day of completion. But the fact remains that there's no effort on the part of the Commonwealth to do anything to stay Judge Morey's decision. It could have tried to do so. And it didn't do so that day. It didn't do so the next day. It didn't do so the day thereafter. In fact, it took no action.
Was the one day that day?
No, the one day was the following day, Your Honor. The judge issued his decision. There was essentially another day to give time to make sure that the restitution was paid, which it was, and no action was taken. And furthermore, it's not that just no action was taken that day or the next day. We have 63 days go by before a 211-3 petition is filed before the single justice. Now, that's also troubling, because if this had been a normal appeal under Rule 4 of the Rules of Appellate Procedure, that appeal would have to have been filed within 30 days of the court's decision. So we have essentially a double whammy. So even if this court is troubled or disagrees with Judge Morey's decision, for this defendant, the case is moot. For this defendant, the Commonwealth did not act at all in a timely fashion to do anything to preserve the case.
Wouldn't you be making the same argument if this were day 3 or day 2? I mean, legally, it's the same, isn't it?
I certainly would be making the same argument, Your Honor. I think I'd have a better chance of success if it's day 63. And it's because it's the double whammy. It's not just the failure to stay, but it's also that the Rules of Appellate Procedure have this 30-day requirement, and here we have a 211-3 petition that's filed 63 days later. What if it had been
All
filed?
right, I mean, they could have, the one day is short, but and it happens all the time, they could have gotten on the phone to the clerk of the appeals court and said, I got an emergency here.
Absolutely.
I'm going to fax in a request for a stay, which would have been routinely granted, because judges do that just to get a handle on things, and not let them get into this kind of situation. Or he could have done it here too, I suppose, but appeals court.
And the fact is, even
So
if
they weren't remediless.
That's precisely correct, Your Honor. They had a remedy. And the real problem is, not only did they have a remedy, but they didn't even try.
Well, they were so shell-shocked by apparently what happened, it took a while to react.
Well, I can't speculate as to what the district attorney's office did or didn't do. However, it would have been a very simple matter for the prosecutor in that courtroom to have asked the judge to stay, and if not, simply to pick up the phone, as you said, contact the appeals court, fax a request in over there for a stay, or make some effort in that regard. And again, nothing was done for 63 days. And so with that, Your Honors, unless there's any further questions.
I have a further
yes,
question.
Your Honor.
Mr. Toledo, in his ruling, and I frankly haven't had a chance to go back and look at it, he points to Rule 29 of the Matzels procedure and, you know, talks appropriately. And then he says, Matzels of criminal procedure 19, Section 29A, formally provided in any district court within 60 days, and I'm reading at page, Record Appendix 11 in the Commonwealth's.
Yes, Your Honor.
Yeah, the Commonwealth's brief, right at the bottom there. Revise the revoke a sentence without a trial after plea of guilty or nolo contendere, and in the event of revocation, permit the withdrawal of appeal upon which the sentence was imposed. What is that all about?
Your Honor, this is Judge Maury's ruling. I can't speculate what was going on in his mind as he wrote it. It seems to me...
From what is he quoting?
It looks to me he is quoting from the former Section 29A, which is a predecessor to Rule 29. I believe that's what he's quoting here, Your Honor.
And so was there a change, a specific change from 29A to 29?
Your Honor, it's not quite clear to me without having the two
Okay.
texts in front of me. I will go back to suggesting that Rule 29 does allow what this judge did here on the face of the rule itself.
Okay. Thank you.
Thank you, Your
Mr.
Honor.
Leda. Gee.